wrote him a letter once and told him I had a little bit of contempt for him. I felt he should have been stronger and ruled differently in many aspects. Not many aspects, a few aspects, in my case.
Judge Schultz described you, and I'm quoting, as having violent propensities capable of committing murder. Are you?
You know, it's a hard question to ask, you know, because I imagine anybody, I think Khalil Gibran, and I put this in the front of my book, says, among the people, there are killers who have not yet shed blood, thieves who have stolen nothing, and liars who have so far told the truth. And whether I'm capable of committing murder would depend on what somebody was doing to me or my family, and what position that I got put into. I've never killed anybody. I've never had any desire to. I've never thought about it. But I think we're all capable of committing murder if we are put in a position, you know, to defend themselves, and or, you know, there's a lot of emotional states, I think, in people's minds that haven't been reached. People that live in one of those flowery worlds that never thinks it happened, you know, and I think you're finding politicians and people every day that coming home and find another guy in bed with their wife that, God, this guy never even had a violent bone in his body. He shot that guy 15 times, found him in bed with his wife. I think for me to commit a cold-blooded, calculated murder, that's not me. You know, I was a street fighter.
You weren't exactly a good guy, though, Mark. You didn't have a reputation as wearing a white hat.
No, my mistake, I guess, was I lived my life openly. And if I didn't like something, I'd let them know right there. And if I liked something, time is smoking pot, I did it. I enjoyed it. I think my worst conviction up to this point was a burglary I did when I was 18 years old. Other than that, I've never been convicted of stealing anything from anybody, hurting anybody else. Most of my convictions were for possessing things that society felt was wrong for me to possess.
Judge Schultz refused to be interviewed about this case, but he provided us with his report to the Supreme Court of Florida, where he states he has serious misgivings about the use of cameras in the courtroom and in this case. He also provided letters from Alfonso Seppi thanking him for taking into consideration that Seppi had been ill and for delaying the start of the Herman trial. Several months before the trial, Seppi had suffered a heart attack and had undergone bypass surgery.
Alfonso Seppi.
Alfonso Seppi I admired quite a bit during my trial. I think Al Seppi suffers right now from a major pride and ego problem, and insofar as this case is concerned. At the time that he was my attorney, he was the only one next to me, as I think I stated once before, that was helping to catch the bullets that everybody was firing at me. It was almost like he was in battle with me, and he was beside me, and I would respect him quite a lot for that. He said a lot of things about the judicial system in Palm Beach County in particular, and the corruptness in this case that satisfied, my feelings. And I don't think that he was prepared or well enough to defend me at the time. I think, as I look back right now, he did a poor job. I feel he could have done better. He claims that he just needed more time to do better. But he made some major decisions that were highly prejudicial that hurt me quite a bit. But I stuck by him for 10 years. I refused to attack him because of my principles. I don't care how many mistakes Seppi made. It was still the state attorney's fault for bringing this case to bar. And it was the police department's fault for prosecuting me, something that I didn't do, and they all know that I didn't do, for bringing perjured testimony up on the stand and using the type of witnesses that they used. And except he didn't do anything but just stand beside me and didn't even open his mouth. I could never blame him for my conviction. That's the state's fault. They used those type of people.
I think Mark is right in part regarding the ego issue. I don't think you could be a trial lawyer and have no ego. So there is an ego issue here, just on the clinical evaluation of winning or losing a case. And I admit to that, and I hope I will always feel that way as a trial lawyer. As to whether or not a poor job was done, there was no, I did not do a poor job. And all you have to do is look at the transcript to see whether or not I sat there and did nothing. I think I was on my feet more than the prosecutor was, and debating the court and cross-examining the witnesses and arguing motions before trial. I was on my feet constantly, and I was constantly in advocacy battle in that courtroom during the trial and before the trial. The answer to that question, did I do a poor job, is that I did not do a poor job. I did an excellent job. I was well prepared, but we lost the case. Now, people look for a scapegoat, and you look to the lawyer. That happens to be a natural inclination. But I ask you and your viewing audience this question. How many people in Palm Beach County that were subjected to the pretrial publicity believed Mark Herman was guilty before the trial began, and by the time the trial was over, as a result of watching the trial in progress on television, changed their minds and believed him to be not guilty when the jury retired to deliberate? And when you all answer that question, you will then decide, that will tell you what kind of a job I did.
The jury, however, found him guilty. How do you resolve that?
How do you resolve juries throughout history that have come up with their own shocking results?
Were you surprised at the verdict?
Absolutely. I was surprised that the state had not proven its case.
Is it possible you should have removed yourself from the case because of your health?
No, my mind wasn't affected. I was not as physically strong, and I had thought that I would get cooperation from the court and from the state in the amount of time that they would require me to be present in the courtroom. And in some regard, I think Judge Schultz did yield to me on one or two occasions, but not too many. So the answer there is, and I think I testified to this, I think I would have done better and been a little sharper, perhaps, had I had more time, had Judge Schultz given me more time. Now, understand, Judge Schultz postponed the case for quite a while for me to recover. And I tried to get a further continuance from him, and he wouldn't grant it.
But doesn't that just stop short of saying you weren't prepared?
No, I was prepared.
Looking back, did Seppi ever feel he needed to present a different defense strategy?
There were no clues as to who else could have done this other than what was just brought out by discrediting the state's witnesses and establishing that there might have been some other people in the cross-examination, via cross-examination, that there might have been some other people who had a motive to kill. And that's all. But how could you go beyond that? We didn't have a major police department to investigate this matter. All doors were closed, and besides that, you don't do that in real life. I mean, this is a situation where we went to trial on a lack of evidence, and there was a lack of evidence. There still is a lack of evidence.
How do you feel now about the fact that no witnesses were called in your defense, that you didn't take the stand?
I'm angry. I'm angry again at Mr. Seppi that he didn't prove that present a defense for me. And I didn't know at the time how many witnesses were available. I didn't know about people that gave the state attorney sworn statements that they saw Dexter forging his confession. I didn't know that there was people willing to come up even out of the state attorney's office to testify and vouch for Dexter's lack of credibility. I didn't know that Billy Glocker wanted to come up and testify that it was all baloney. In fact, I thought that the state was going to call him up, and when they did, and I asked Mr. Seppi, "We don't need any witnesses. There's no case." And as I look back now, I know how naive I really was about the judicial system, even though I had been in trouble quite a few times than before it, but not in any magnitude like this, or this type of seriousness. And had I been knowledgeable, knowing that I did partially pay Mr. Seppi some money, and knowing that he worked for me, he wasn't up there doing me a favor, and I would have demanded more things be done. But I felt that, hey, this guy's a judge, an ex-judge, so he's got to know what he's doing. You know, I wouldn't go in the operating room to be worked on by a doctor and tell him what to do to my body, and I wouldn't even dare. So I have to trust him. I have to believe that whatever he says, whatever he does, he's doing is the right thing. And that's what I did.
Stephen Johnson is Mark Herman's clemency attorney.
I think that, number one, I'd have put Mark Herman on the witness stand to testify that he didn't do it. Definitely would put him on the witness stand to testify. I would definitely have had a handwriting analysis, FBI analysis, or someone, an expert in document examination to testify as to the Dexter Coffin case. Definitely would have not allowed the summary of the alleged confession by Mr. Herman to be put into evidence as it was allowed. I would have definitely put it on Billy Glocker to testify. Our investigation has uncovered probably 3 or 4 different theories of who did it. We've even discovered one witness that went to the Palm Beach County Police Department and said this individual came back with some money and was shaken and talked about that they had done a murder the day before, not Mr. Herman. There was so much evidence available by a good defense lawyer to use.
However, when there is a lack of evidence, it is considered to be a smart tactic by many criminal defense lawyers to give up introducing evidence during the course of the trial in exchange for getting the last word in closing arguments before the jury.
Was Mark Herman at a disadvantage?
As a consequence of his legal representation? I don't think so. I don't think that Mark received inadequate representation of counsel. Now, that's not to say that if I were on the other side, I would not have made some different tactical decisions than Mr. Seppi made. But those are matters of tactics and matters of style. He chose, for example, at one point during the course of argument, to suggest the possibility that Mrs. Kreuzler may have had some hand in her husband's death. I think that was a serious tactical error on his part. And I think in retrospect, it would be unlikely that he would repeat that suggestion if the case were to be retried in front of another jury.
According to Joe Mintzberg, Alfonso Seppi admitted during an evidentiary hearing he didn't have enough time to prepare the Herman case.
The fact of the matter is that Mr. Seppi was in no position to evaluate the case because he wasn't prepared to do so. He was scrambling around by his own admission to learn the state's case. And lo and behold, he's on the eve of trial, and he's still reading police reports, having not yet begun to prepare a defense case. So his exclamation or explanation as to why he didn't present a defense is really lame, because he was in no position to evaluate the defense case because he hadn't even started to develop one.
There were no alibi witnesses. There was nothing to defend Mark on. The murder had happened months and months, or maybe a year, I don't remember now, but at least a year and a half before the... Now, I've been criticized supposedly by that buffoon, Rivero, or Geraldo Rivero. Well, who knows what his real name is, but in a 2020 broadcast in which he said that I chose to depend more on my elocution and my oratory ability to preserve a final argument than put on evidence. There was no evidence.
And the public has to remember that the state changed its theory during the course of the trial. It moved from claiming that Mark went to kill the Kreutzers to the fact that Mark supposedly went to kill, what was the name of that guy? Glocker. Now, you please explain to me what I could do with that, other than to show the preposterousness of it. Put on Mr. Glocker as a witness, and how is Mr. Glocker going to testify that Mark didn't intend to kill him? How does he know? Do I know what's in your mind? How could Glocker testify to that?
Apparently, Glocker didn't know Mark.
No, that's not true. They knew each other. And besides that, Mark didn't know Kreutzer either. Is that an answer?
Jack Scrolla.
Jack, I feel, was a brilliant attorney. I respect him for his mind. I have contempt in how he used it. I think that Jack Scrolla was a political whore at the time. He used my case to try to run for the state senate. And he failed on that, but I was his forum, and that's all he saw me as, was something to bring his own self-esteem up, popularity in the community, legal community, and I was nothing more than a stepping stone for him. And he was unconcerned whether I was guilty or whether I was innocent. And I think his job as a prosecutor should have been to seek the truth, not just to convict. And he went out to do nothing but convict, and then truth be damned.
I don't know that those kinds of comments warrant the dignity of a response, Jane. I'll stand upon my reputation in the community. I took my responsibilities as a prosecutor very seriously, including the ethical responsibilities I had. I never prosecuted an individual whom I did not personally believe was guilty of the crime for which they were being prosecuted. And Mark Herman's case was no exception to that. I think that's about the only response that I can make.
Is there the possibility the wrong man was sent to prison?
I think that in any case, and particularly in any case that relies largely upon circumstantial evidence, a possibility exists. A possibility exists with regard to all matters of human affairs. But we don't make decisions based upon what is possible. We make decisions based upon what is probable, and with respect to matters relating to the criminal law, what's been proven beyond a reasonable doubt. There may be doubts about Mark Herman's guilt, but those doubts were judged by a jury not to be reasonable doubts. There may be new doubts, but there has been no demonstration that any of those doubts are reasonable doubts either.
You may be asking, after all these recantations and indications that perhaps the wrong man is in prison, why haven't the appeal courts chosen to overturn or retry the case?
Once a jury speaks, the law makes it very difficult to set aside that verdict. The law with respect to recantation of witnesses, where witnesses at a trial at some later date say that what they said at the trial was wrong or a lie, is very difficult to succeed on in getting a new trial. The court, in this case, we did, in fact, the first thing we did was pursue these recantations. Even before we raised the issue about Mr. Seppi's competence, we pursued the issue of recantation. The 4th District Court of Appeal simply said, sorry, you guys waited too long. And we pursued that to the Florida Supreme Court and got a very simple denial, which happens quite frequently on these appeals, discretionary appeals. The Florida Supreme Court does not have to hear every case. Some cases they hear and some cases they don't. This one, unfortunately, was one they chose not to hear on the issue of recantation. The fact of the matter is that the requirements of the law are so severe that the Coffin recantation, where Dexter Coffin went on national TV and said he forged the confession and lied at Mark's case, was not under oath. So it was very difficult for a court to rule that it was an official recantation, so to speak. The Baines and Gibson recantations were, in fact, under oath and in transcript form. But the courts felt that they were minor players at Herman's trial, and the fact that they recanted was not likely to have changed the result. DeNono, of course, is protected by the federal government, and he's not available to recant. So we did not have a case that was likely to succeed in the state system.
The issue in these post-conviction matters, and I'm sure you're aware of this, Jane, is not whether Mark Herman is guilty or innocent. That's already been determined by a trial court. The issue is whether he received a fair trial. If the issue were whether Mark was guilty or innocent, I think many courts would have already ruled that the evidence would have been insufficient had those courts been the trier of the fact. Of course, the jury in Mark's case was unaware of many of the things that we in the public and we that have known Mark are aware of. The jury was unaware, for instance, of the evidence that I believe that Mr. Mintzberg has presented, that the confession or alleged confession could not have been written by Mark Herman. The jury was not aware of Dexter Coffin's problems in as much detail as I think they could have been made aware of. So we're operating in a knowledge-filled environment that the jury did not share.
Jim Edwards, news director and investigative reporter for WJNO Radio in West Palm Beach, became interested in the Herman case a few years ago and spends much of his free time tracking down leads and looking for proof of who it was that killed Richard Kreuzler 10 years ago.
During your investigations, have you ever found a motive or any evidence that links Mark Herman to the murder of Richard Kreuzler?
None whatsoever. None. Absolutely nothing. The police found no physical evidence linking Mark Herman to the murder. I have found no physical evidence or a motive linking Mark Herman to this murder.
How many theories have you explored?
Two or three. The original investigators, and I can tell you this from looking, they have 5 file boxes full, packed full of single sheets of paper. They explored, to give you a good example, if a normal murder investigation looked like a wagon wheel, and each spoke in that wagon wheel was a theory, then the Kreuzler murder investigation looks like a bicycle wheel. And imagine how many spokes are in that wheel. They investigated at least 20 to 25 different theories that looked excellent, every one of them, up until the last minute when something would show that that wasn't it. When I started looking into this, there were a few people who said, if you get the opportunity, look for the so-called Wiseman report. So the first thing I did is I had the lawyers for our radio station write a public records request to David Bloodworth to open up the entire file on the Richard Kreuzler homicide investigation. They did so without any qualms whatsoever. In fact, there were 5 file boxes containing information. So I started looking through the boxes, and lo and behold, I found the so-called Wiseman report. And in that report, Joel Wiseman named somebody else besides Mark Herman as being involved, in his opinion, in the murder of Richard Kreuzler, a fellow named John Crotty.
Joel Weissman, now in private practice in Palm Beach, was an assistant state attorney in the office of David Bloodworth.
Joel Weissman, why were you initially asked to conduct what has become known as the Weissman report?
There was a lot of public furor over the conviction of Mark Herman. David Bloodworth asked me to investigate the various theories that other people may be responding. And I undertook that investigation.
What were your conclusions?
The conclusions were that I couldn't find any evidence at that time to say that Mark didn't do the crime, going on the assumption that the jury verdict was correct. However, I thought that a person by the name of John Crotty was Mark's accomplice, and I provided that information to Mr. Bloodworth.
In your opinion, why was that report kept under wraps, suppressed?
Suppressed. I think the information contained in the report would lead one to the conclusion that Mr. Crotty had some information concerning Herman, or if it wasn't Herman, who else was responsible for the Kreuzler killing. If that report was made known, then it would have given fuel to the fire that Herman was innocent. Because as that later turned out, and I'm talking about just a few months later after that report, Coleman called me from South America and recanted the testimony. And the no-no, who was a major witness in the case, had substantial assistance from the very same people who were prosecuting Herman, so that he would not get the death sentence. So if all of those things were known immediately after the Herman conviction, or as close to having it known as possible, I think that there would have been more of a furor than there was.
Would you care to speculate as to the reasons why no one wanted to see that become public?
I was told that the investigation was still continuing, that my conclusions were erroneous, and that they were reinvestigating my own conclusions that I made in that report.
To the best of your knowledge, did that investigation continue?
I never heard of another person looking into the allegations and statements that I made in my report since the time it was submitted.
State Attorney David Bloodworth refused to be interviewed for this report, and he wouldn't address specific criticisms of his office or answer specific questions that we asked. But he did provide us with a series of documents which reflect his general position. In those documents, Bloodworth questions the objectivity and credibility of Tim Pallison, Joel Weissman, and Stephen Johnson. In November 1986, Bloodworth wrote to Governor Bob Graham, "The report, when finished, was and has been available for review by any person who sought access to our files." In December 1986, Assistant State Attorney Richard Barlow wrote to the editor of the Palm Beach Post stating that Weissman had changed his conclusions as to who murdered Richard Kreuzler 3 times. Barlow quoted from the 1979 Weissman report that Weissman concluded, unequivocally, "I am convinced there is no substantial evidence to find anyone but Mark Herman committed the crime in which he was convicted." However, what Barlow doesn't refer to in his letter is that in the next sentence of the report, Weissman goes on to name a possible accomplice. John Crotty, in my opinion, was not a witness but an accomplice with Mark Herman.
Mr. Weissman tells me he was asked to investigate a theory of a Jake the Snake theory. He was not to investigate whether Mark Herman was guilty or not. That was assumed because Herman had been found guilty. He was to further investigate other theories that appeared to have some relevance. Based on his investigation, he tells me he came up with the conclusion, not about Mark Herman, because he assumes Mark Herman is guilty, but he came up with the conclusion that